So for the agenda today, we'll be starting off with an introduction to our HIV in the Law project and the relevant legislation that applies to confidentiality with people living with HIV. And we'll then have a group activity where you'll discuss some of the case studies that I sent last night, and but I can also pop them in the chat, and we'll be applying the kind of legislation that we've learned about beforehand. I'll then present again on how we can challenge breaches of confidentiality. And like I said, at 10:30, Adam will be joining us for a Q&A session, and we're scheduled to finish at 11. Can I just check if anyone has any issues before we begin? Cool. I can see Hannah's face looking like there aren't any issues, so I'm going to take that as a no and proceed. So as I mentioned, that this training is part of the HIV in the Law project. So apologies to those of you who've already attended the previous sessions and are now very familiar with this project. But I've included in this slide our theory of change to give you a sense of what we're trying to achieve. So the overarching goal of this project is that people living with HIV should face less discrimination from employers and services. And we think this can be achieved by enabling staff from HIV support services, such as yourselves, to inform people with HIV of their rights. So and provide them with effective advocacy. And it's also crucial that employers and public and private service providers are aware of their legal obligations towards people living with HIV too. So we're implementing 3 types of activity to reach these outcomes, and these are training, information resources, and also a service where we can give you advice and support when you are helping a client challenge unlawful discrimination. And as part of this project, we work with 2 solicitors, one of whom is Adam, to give us legal advice which informs the support that we give in this project. And it also requires staff from HIV organisations to get in touch with us, seek our advice, and use our resources. And I've worked with a number of you who are on this call now on discrimination cases, and I'm really grateful to you all for attending this training and just engaging with us on this project. So I'm going to talk a little bit about why this training should be relevant to you. So everyone is entitled to certain protections under the law, and therefore the law can be useful in holding employers, public and private services, and the government to account. And it's not just about going to court. There are many ways that we can use the law to promote the rights and to promote and protect the rights of our clients. And whilst there are some people who don't share their HIV status outside of their HIV clinic, but most people do choose to share their status with others, and whether this is their employer, family or friends, other parts of the healthcare system. And it's really important to know how to protect their confidentiality and challenge it if it's unlawfully breached. And having a session specifically on breaches of confidentiality is informed by the fact that a lot of the cases that come through the discrimination advice service that I mentioned relate to confidentiality. And legal protection for confidentiality of health-related information is based both on common law, which is law derived from court judgments, not acts of parliament, and statute law, which is from acts of parliament and secondary legislation. And the common law duty of confidentiality can be summarised as information provided in confidence should be treated as such and not divulged to third parties. And all identifiable information, whether this is written, computerised, visually or audio recorded, held in the memory of people at an organisation is subject to the duty of confidentiality. And a breach of confidentiality is when data or private information is disclosed to a third party without the data owner's consent. And this could be an intentional breach, accidental error, or theft, for example. But it's not always unlawful to share someone's data without consent, and that includes someone's HIV status, and it's uncommon, but we will cover this in the session. So moving on to the key legislation relevant to people living with HIV, these are the Data Protection Act 2018, which is GDPR in the UK, the Equality Act 2010, and the Human Rights Act. And I appreciate that everyone here will have varying levels of understanding and knowledge about these laws and specifically how they apply to confidentiality of people living with HIV. So we're going to go through each law so that we all have a good understanding, but we'll be focusing mostly on the Data Protection Act. So starting with the Equality Act, though, this law is the main form of protection against discrimination for people living with HIV. And the Equality Act covers most aspects of life under 3 key areas. And this is employment, goods, facilities and services, which includes consumer services, rented and private property, utilities, financial services, transport and leisure, and also public services, which includes health, social care, benefits, public housing services, police and the courts. And there are also 9 protected characteristics in the Equality Act, and discrimination which happens because of one or more of these characteristics is unlawful. So we all have some of these characteristics, for example, sex or age. So the Act protects everyone from discrimination. And although people living with HIV might not personally identify as disabled, they are afforded protection under the Equality Act because HIV is legally classed as a disability from the point of diagnosis. So moving on to the next piece of legislation, you probably will have all heard of the EU's General Data Protection Regulation, of GDPR. So the Data Protection Act is the piece of legislation which brings the requirements of GDPR into UK law, with some additional requirements too. And the Data Protection Act is a huge piece of legislation which governs how organisations process our data. It aims to ensure that people can trust organisations to use their data fairly and responsibly. But because every organisation is different, data protection law doesn't set many absolute rules, and instead it takes a risk-based approach, which is based on some key principles. The first is the principle of lawfulness, fairness, and transparency, which just requires that data is processed in a lawful, fair, and transparent manner in relation to the individuals who own the data. The next principle is purpose limitation, which means that data must be collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with these purposes. One of the most relevant principles to people living with HIV is the principle of data minimization. And this states that data collected must be adequate, relevant, and limited to what is necessary. And this means that organizations collecting the data should collect enough data to fulfill their stated purpose for collecting it. And it means that the data that they are collecting has to have a rational link to that purpose. And they must not collect more data than they need for fulfilling that purpose. The accuracy principle requires that data is accurate and, where necessary, kept up to date. The principle of storage limitation states that data is kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which that personal data are processed. So this means that data can be anonymized after a period of time. Another relevant principle is that of integrity and confidentiality, which states that appropriate security measures must be in place to protect the personal data held. So, for example, if your client shares their HIV status with just their employer, it's not stored in such a way that all the company employees can access that information. And accountability means that organizations are responsible for complying with the Data Protection Act and must be able to demonstrate compliance. And because the Data Protection Act is principle-based, the lawfulness of an action can vary depending on the situation, but it doesn't mean that it's always illegal for someone to ask about your HIV status. So we'll come back to the Data Protection Act and how it applies in various settings in a moment, but I first just need to quickly mention the Human Rights Act of 1998. So this is a piece of legislation which brings the European Convention on Human Rights into UK law. And the Human Rights Act describes rights as a series of articles, particularly relevant articles to the confidentiality of people living with HIV is Article 8, which is the right to private and family life. So private life, among other things, includes an individual's physical and psychological integrity and the collection and publication of personal information. And Article 8 acknowledges that personal information is private, and it recognises an individual's right to physical and psychological integrity, which could be damaged through unnecessary disclosure of personal information. So Article 8 places a positive duty on public authorities to protect and promote the right to respect for dignity and personal autonomy of individuals. And this means they must be proactive in their attempts to protect personal confidential data and respond effectively where breaches have occurred. And in addition, they must inform and explain to individuals when there is a risk that their human rights may be violated. But importantly, Article 8 is not absolute. It's a qualified right. So conditions where obligations can be set aside include where it's necessary to protect public safety and health and to protect the rights and freedoms of others. So adjustments must be proportionate and kept to the minimum necessary to achieve the legitimate aim. And the application of common law principles also must be executed in line with Article 8. And finally, another article that's relevant is Article 14, which is the right to be free from discrimination. But this can only be used together with another article in the Act. And the Human Rights Act is a really important piece of legislation because it's about holding public authorities to account, and it allows individuals to take action against public authorities that have interfered with their rights, and that could be local authorities, the police, healthcare services, and importantly, the government too. So while it's helpful to understand this legislation, it's probably a little bit more helpful to understand how these laws apply in settings where people living with HIV are more likely to have their confidence breached. So we're going to begin with employment, and specifically pre-employment health questionnaires. So Section 60 of the Equality Act makes it unlawful to ask health-related questions prior to the offer of a job. And there are a few exceptional circumstances where employers can ask, and this is to find out if you can take part in any assessment to test your ability to do the job, or to find out if reasonable adjustments are needed to enable you to take part in any assessment if you are disabled. But these questions should not be HIV specific or ask about medication. Yeah, they're unnecessary for most jobs because, but if they are asked, it just shouldn't mention anything about specifically about HIV or bloodborne viruses. Post-employment health questions are quite common, and we get quite a few people getting in touch with us about concerns about sharing their HIV status with employers after a job offer has been made, or even after a job has been started. So employers in occupational health are not prevented from asking disability and health-related questions after a job offer is made. They're expected, and they're also expected to do all that they reasonably can to find out if an employee has a disability in order to assess whether reasonable adjustments need to be made. But again, these should not be HIV specific. Employers should be really clear about the purpose for asking health and disability related questions and be satisfied that this is justified by real benefits. So generally, workers should not be routinely asked to disclose their entire GP record, for example, but instead employers should ask specific relevant questions to elicit only that information required for the particular purposes. So if the question being asked is to determine if the employer can make reasonable adjustments, the question should be about any condition classed as a disability under the Equality Act, and not, do you have HIV, or please list all the medications that you're taking. The employer should also have systems in place to protect the confidentiality of this information to comply with the principle of integrity and confidentiality. So, and any dismissal or detriment following disclosure of HIV status could lead to having an action in respect to disability discrimination. And sometimes the implied terms of mutual trust and confidence might form a part of the employment contract. And this means there would be a duty on the employee and the employer not to act in a way that is likely to destroy that trust and confidence. And it's possible that not sharing the true information about health and disabilities could satisfy the test for a breach of mutual trust and confidence, but this is very rarely used. It may also be considered that being asked to provide health information is considered to be a lawful and reasonable order from an employer, which would mean failure to provide this information is considered as misconduct, which could lead to disciplinary action. Specific to healthcare settings, in 2019, the UK Advisory Panel on Healthcare Workers Living with Bloodborne Viruses published new guidance on when healthcare workers are obliged to share their HIV status with employers. So for healthcare workers who are not conducting exposure-prone procedures, which is the vast majority of healthcare workers, there is no formal obligation to share HIV status with employers. And for healthcare workers carrying out exposure-prone procedures, then anyone starting these roles within the NHS must test for HIV. And if that test comes back positive, that's okay, provided they register with a national database and submit quarterly viral load tests, which shows that they're taking their medication and that their viral load is suppressed. And I've gone into quite a lot of detail about post-employment health questions because there really isn't any kind of strict legislation or guidance. Ultimately, it's up to your client whether they do or do not want to share their status with their employer. But it's important to note that not sharing your HIV status with employers or occupational health means that they won't be able to benefit from some of the protections provided under the Equality Act. But equally, there's very rarely a need for your employer to know. Occupational health then is a type of medical service which seeks to support employees and employers and help well-being in the workplace. And it can be really useful for people living with HIV in the workplace if they do choose to share their status with their employer. But it's important to understand their role and how it relates to confidentiality. So occupational health can be through their company's own occupational health service or provided by an outside agency. And any information that we provide to occupational health regarding health or disability will be assumed knowledge of the employer too. So it's usually not possible to share information with just occupational health, but it is possible to ask occupational health, not to share that medical information with managers or colleagues, for example. So you can limit who in the company is made aware. Sometimes occupational health might need to get more information from an employee's doctor, and this can happen, for example, after a period of extended absence. And the employee should be told the reason and asked to sign a consent form before they make contact with the doctor, with the GP. And the employee has a right to see the doctor's report before it is sent to the occupational health advisor. And if an employee refuses consent, then that information should not be sent, apart from in the limited circumstances where it's required by law or can otherwise be justified. So if your client has chosen to share their HIV status with their employer, then that information must not be shared without their consent to anyone else. And it's wise for employers to have confidentiality or non-disclosure agreements in place as part of employment contracts. So your clients can review these before they make a decision. Employees have the right to know which records are stored about them and their use, along with how confidentially they're kept. And employees can find this out by making a subject access request. But employees are also entitled to know the connection between storing this information and kind of like why it's necessary. What's the purpose of storing it? So harassment is a form of discrimination that's prohibited under the Equality Act, and it's defined as unwanted behaviour with which a person with a protected characteristic finds offensive or which makes them feel intimidated or humiliated. And it can take place in various settings that are protected under the Equality Act. So in employment, so employment is one of them. And an example could be a colleague of your client repeatedly makes threatening phone calls saying that they're going to tell your client's boss and family that they're living with HIV. And harassment doesn't have to be intentional either. This means that it can be harassment even if the person harassing you didn't mean to offend or intimidate you, as long as the harassment has one of the above effects. And if you do go to court, the judge may have to decide if it's harassment or not, and they'll look at how the behaviour made you feel and whether it's reasonable for you to feel this way. And later on, we'll consider how to challenge harassment, depending on where it's happening. But the next setting we're going to consider is healthcare. So as well as the legislation that we've already mentioned, there are specific NHS policies, commitments and contractual obligations which set out clearly the confidentiality expectations for all NHS services. And some of the key documents are the NHS Code of Practice on Confidentiality, the NHS Care Records Guarantee, the NHS Constitution, Records Management Code of Practice, and also the Caldecott Principles. So this was formed in 1997 after a committee chaired by Dame Fiona Caldecott produced a report on confidentiality. And their brief had been to review the transfer of identifiable patient information within the health service. And the result was a set of standards that became known as the Caldecott Principles. And in 2013, another review was published, which expanded on the 1997 report. And it had 27 extra recommendations and also a 7th principle. So each organisation has an appointed Caldecott guardian who's responsible for safeguarding patient information and ensuring good practices are implemented. There are also protections afforded through regulators. So the General Medical Council publishes, in addition to its key regulatory resource for doctors, Good Medical Practice, they publish additional guidance called Confidentiality, Good Practice in Handling Patient Information. And the Nursing and Midwifery Council has a code, standards of conduct, performance and ethics for nurses and midwives, which contains confidentiality duties, as well as they also have a regulation in practice topic on confidentiality too. And there is similar relevant regulatory guidance from the General Dental Council, the General Pharmaceutical Council, and the Health and Care Professions Council. And healthcare professionals must be prepared to explain and justify their decisions and actions with regards to confidentiality. But only serious or persistent failure to follow the regulator's guidance that poses a risk to patient safety or public trust in doctors could result in them being unable to continue to practice. So specifically considering confidentiality within sexual health services, information from a sexual health clinic is stored securely and is not shared with other parts of the same hospital without the consent from the patient. So data is also not shared by sexual health clinics with GPs without consent. And before the sexual health service shares some or all of your clinic records with another part of the NHS, the patient would have to agree for them to do so. Most people living with HIV do choose to share their records with their GP. So Positive Voices survey found that 98% of respondents who were registered with a GP, so of those 98%, 94% had shared their HIV status with their GP. And GP disclosure was slightly lower among certain demographics, and that included young people aged 18 to 34, trans people, people of white but non-British or Irish ethnicity, and other non-Black African minority ethnicities. But even among these demographics, it was still quite high at between 89 and 90%. So summary care records are an electronic record of important patient information created from GP medical records, and they can be seen and used by authorised staff in other areas of healthcare, other areas of the health and care system involved in the patient's direct care. So patients can opt out of having their summary information uploaded onto the summary care record, and patients will always be asked by a healthcare worker for permission to access their care record unless the patient is unable to provide consent. And there's also a really clear audit trail of who has looked at a summary care record, as it's only accessible by logging in. And only healthcare workers directly involved in your care can look at your summary care record. And once a patient has given consent, this consent extends to all healthcare workers who are directly involved in their care. Sometimes GPs will be asked to provide information to third parties, and insurance reports or kind of reports and requests from employers are the main form of requests. An insurance company will usually send to the GP a signed consent form from the patient agreeing to the release of the information. And the request for information will also say whether the patient wishes to see the information before it is sent out, plus any further guidance. And similarly for employers' requests for information, it's expected that the GP will satisfy themselves that the patient understands what's involved in the disclosure, has consented to it, and they'll also offer to show the patient or give them a copy of any report that they write about them. And if a patient refuses consent, the information should not be sent. But whilst in the past the doctor would write a letter and include relevant information, the existence of the summary care record means it is now much often easier just to send that, which may well mean that the processes have become a little laxer and more information than is strictly necessary might be being shared. And guidance from the General Medical Council makes it clear that only information relevant to the request should be disclosed. So you should not usually disclose the whole record. But exceptions to this are some benefits, claims, and litigation, where solicitors sometimes ask for and have the right to the whole record of someone. And this could be, for example, in kind of negligence or compensation claims. But just as the GP should not include irrelevant information, obviously they should not leave out information which is relevant at the same time. And it's also important to consider the kind of rare circumstances where breaching confidentiality can be lawful. So there are a few extremely uncommon situations where the normal rules of confidentiality may not apply. And this is if a court requests the information. In some cases, if the police request information, but that's also quite rare. And if a doctor believes that someone living with HIV is putting the life of another person in danger. So such cases are expected to be exceptional, and in most instances, there should still be, an initial first attempt to secure patient consent. And common public interest considerations include the prevention, detection, or prosecution of serious crime, or to prevent the spread or reduce the risk from serious communicable disease. So the General Medical Council guidance on confidentiality sets out in some detail the process and considerations to bear in mind in such cases. But for people living with HIV, it's the latter context about communicable diseases which may be the most relevant, since the guidance does allow the clinician to disclose without patient consent to a current or former sexual partner of someone diagnosed with HIV that they might be at risk. But it's really important to note that this is permissive, not mandatory. In other words, the clinician can override consent, but is not obliged to do so. And it's also possible that the clinician deems the risk of harm to the patient or to confidence in the confidentiality of the clinic to be more significant than the concerns about sexual partners. And it would also be expected that such non-consensual partner notification would be a last resort after extended and intensive efforts to secure the patient's consent. And in most cases, the partner notification process can persuade the individual to permit their HIV status to be disclosed to current or past sexual partners. So moving on to another setting, which is confidentiality in the police, which we'll cover briefly as it's less commonly reported to us as an issue compared to employment and healthcare, but it's still important. And so, yeah, HIV status is definitely, it's confidential medical information, and it should not be identifiably recorded by the police unless it is to ensure timely access to medication. And and it also should only be stored with consent from the individual living with HIV. And HIV status should never be recorded anywhere as contagious or ailment. In investigations involving one or more people living with HIV, investigators must take great care not to disclose an individual's HIV status to third parties, except in those limited and permitted circumstances where it's absolutely necessary for the purpose of that investigation. And healthcare professionals should not release information to the police unless patient consent has been verified or there is a court order in place, except in incredibly limited circumstances, which are defined by the General Medical Council. But in general, the police don't have access to more information than other people unless there's a court order in place. We receive some cases regarding we receive some cases regarding people's HIV status being shared without consent by someone in their personal life. So for an example, a spouse, a family member or a friend. And sometimes people in your client's personal lives betray their trust and they share it without their consent. And this is obviously really upsetting and distressing when it does happen. If this amounts to harassment and is connected to the areas of life covered under the Equality Act, so that's employment, goods and services or public services, and connected to a protected characteristic, which would be disability if related to HIV, then it's unlawful discrimination under the Equality Act of 2010. But if it's breached by someone in their personal life, then it's unlikely to be connected with these areas of life, and legal protection is really limited in these areas. But Adam's going to go into more detail about this in the Q&A at the end, as it's a very complex area to navigate. So we're now going to move on to taking action to challenge unlawful breaches of confidentiality. So whether data has been breached by an employer, an NHS trust, a police officer or another organisation, the first step is to make a complaint to the organisation first. So always try and encourage your client to keep a really good record of the situation as it's unfolding. So that includes key dates, people, copies of emails, time and time of phone calls, making notes about in-person conversations. It will just make it much easier when making a complaint if you have all this evidence to hand. And it's usually good to advise your client to write a letter, or for you to write a letter on their behalf to the organisation who breached their data. So it just has to be in written form. It doesn't have to be a formal letter, but it's advisable. And National AIDS Trust are working on a template letter, which will be downloadable from our website to support this stage. But in the meantime, a suggested letter structure would be a factual description of events, which includes dates and names, job titles, if known, why this amounts to unlawful behaviour and which laws apply. So whether that's Data Protection Act, the Equality Act, or the Human Rights Act, and it can be all, and it can just be one. But it's just good to include which apply in the situation. And then it's good to also include the impact that this has had on your client, and this can be physically, emotionally, financially, an opportunity to say kind of the human impact that this breach of confidentiality has had. Then if you include like the next steps, what your client would like to see as a result, what can the organisation do to resolve this, and also give a deadline to respond. So 2 weeks is usually reasonable. So if the breach of confidentiality happened in a healthcare setting, then obviously the organisation that you'll be writing the complaint to is the hospital trust. So it's good to write initially to the Patient Advice and Liaison Service, and they will support your client to resolve the issue informally. But if their response is unsatisfactory, or if it's not meeting the request that you have, then you can also write to the Chief Executive of the NHS Trust. And if the issue is relating to primary care, you can write to NHS England, or if it's related to secondary care, kind of hospital care, then you can write to the Clinical Commissioning Group. And if you have complained to the hospital and are not satisfied with the result there either, you can contact the Ombudsman. And in England, this is the Parliamentary and Health Service Ombudsman, and in Wales, it's the Public Services Ombudsman. And in Scotland, it's the Scottish Public Services Ombudsman. And the time limit for complaining to the Ombudsman is 12 months. So they are really considered a kind of last resort of complaints that are unresolved within healthcare settings. Yeah, that haven't been resolved via the kind of more formal internal complaints procedure. So in healthcare settings, the Ombudsman is one avenue to consider and definitely worth making the complaint to. But the regulator for the Data Protection Act in all settings, healthcare, employment, and otherwise, is the Information Commissioner's Office, or the ICO. And they require that your client must make a complaint to the organisation first in writing, which is why the letter I just mentioned is an important first step. If they're not satisfied with the response, or they don't receive a response within 1 month, then your client can make a report to the ICO. And if the ICO think that an organisation has not complied with its obligations, it can give advice and ask it to solve the problem, and it can also issue fines. And it's always great to advise your client when they're making a complaint to the ICO to include your contact details of the support service, or National AIDS Trusts, so that the ICO has a point of contact if they do need more information about HIV specifically. And it's important also to note that the time limit for a complaint to the ICO is within 3 months of your last meaningful contact with the organisation concerned. So it's a very short time limit. And when you make a complaint to the ICO, you'll have to select whether the complaint is about accessing personal information or about the way an organisation is handling or processing personal information. And you must also provide details. So it's helpful if this is arranged chronologically and clearly identifies what information was shared and why you feel it's unlawful. You must also submit the initial kind of letter or written form of complaint that you submitted and any response that you've received. You are also asked what more the organisation could do to resolve the complaint, and this can mirror the asks from the letter of complaint that you sent initially as well. So support services play a really crucial role in all of this. So in addition to helping draft a letter of complaint, or even sending a letter of complaint, citing the relevant laws and regulation, support services can also submit a complaint to the ICO on behalf of their client. And obviously this is capacity dependent, and your client might prefer to do it themselves as well. But it's just important to note that it is an option. If you are supporting someone who is really struggling with that aspect of reporting it, then you can submit a report on behalf of someone else. And also the provision of peer support, or just like wider support. So we haven't considered it much in this session. We've been very much focused on kind of like the legislation, but it's obviously can be and often is incredibly stressful and upsetting if your medical information is shared without your consent, and support services are really best placed to consider the needs of their service users more holistically, whether that is through linking them with peer support, providing wider emotional support when necessary too. And because it can be a really stressful experience, often people feel like they're not really in a position to challenge unlawful breaches of confidentiality immediately, and they kind of take some time to process it, and then by the time that they feel up to making a complaint, they realize that they've missed the time limits to bring that complaint. So support services who understand how to address breaches of confidentiality can inform service users of time limits for making a complaint to the ICO and also bringing a claim in court where relevant. So that's also a really key aspect of that support services can provide, because we receive quite a lot of cases where people have missed time limits, and that is across all forms of discrimination in all settings. But the time limits are really, really important, and they're very, very strict. So the Information Commissioner's Office cannot offer compensation, even if they do find an organisation did breach your client's data. So it's also important to note that the Data Protection Act is enforced by the courts, and that's the County Court in England and Wales and the Sheriff Court in Scotland. And the time limit for legal action is 6 years less 1 day from the date of the data breach. But we've discussed how people living with HIV are protected by harassment related to their HIV status by the Equality Act. And if your client is being harassed by in an employment setting, then they're advised to follow their employer's grievance procedure and make a claim to the employment tribunal within 3 months. And that's not just, that is specifically for harassment, which can be linked to kind of confidentiality. In the example I gave earlier was a colleague threatening to tell other members of staff about someone's HIV status, and that would be harassment. So yes, if it's related to harassment at work, then you would make that claim to the employment tribunal within 3 months of the incident. But if harassment is taking place in other settings, but still in settings protected under the Equality Act, so the provision of public services and like goods and facilities, then the Equality Act is enforced by the courts, and this is the County Court in England and Wales and the Sheriff Court in Scotland. And the time limits for bringing legal action under the Equality Act is 6 months less 1 day from the date of discrimination. So 3 months less 1 day for employment tribunal and 6 months less 1 day for the discrimination, for discrimination in other settings. So if your client is being harassed but not in an area of life protected by the Equality Act, or they've had their confidentiality breached by someone that's not in an area of life that's protected under the Equality Act, then legal recourse is possible to prevent further dissemination of personal information or remove information that has already been shared online, for example, by way of an injunction. And Adam's going to go into more detail on this in a moment, but it's just important to note that if there would be no legal aid available unless the legal aid agency can be persuaded that the breach of confidentiality was so severe that human rights breaches would occur if funding was not granted. So yeah, it's just really important that your client would consider if this is worth it once the information has already been shared. And unfortunately, sometimes the damage may already have been done. So taking steps to prevent further dissemination might be pointless, but your client is best placed to think, best placed to assess what they think is the best steps. So there are really important things to consider with regards to taking legal action in general. So the Positive Voices survey in 2017 found that of those who needed legal advice, 2/3 of respondents couldn't or didn't try to access it. And legal action may not always be appropriate either. And that could be because, like I mentioned earlier, your client might already be outside of the time limits by the time they're raising the issue with you. And also the limited availability of legal aid or pro bono support means that legal action is really off limits for lots of people. But I hope I've shown you also how you can use the law to get the best outcomes for your clients without necessarily having to go to court. So a well-written initial letter of complaint can be really effective when it sets out why a breach of confidentiality is unlawful. And people don't want to fall foul of the law and will often take steps to resolve the issue without needing to go to court. And the Information Commissioner's Office can also be a really useful resource in taking action against organisations. So even if legal action is not an option, we always recommend that you flag the breach of confidentiality with NAT, as it's useful for us to build evidence of widespread discrimination to tackle that as well. And it's also, within those very strict time limits that I mentioned, it's always advisable to seek advice first if you're unsure of the situation. So with such short time limits, it's good to check with your client as soon as possible if they can access legal aid or they can access legal support via trade union membership or home contents insurance, for example. So I've included some links on this slide with some more information. And many of you have already done this, but if you are working on a case involving discrimination, then you can always get in touch with National AIDS Trust Discrimination Advice Service. The email's up here. And we can provide kind of initial legal advice and guidance too.